from Iloilo is recognized.
Thank you, Mr. President. It appears to me that we have come to the point in this impeachment trial when we are faced with the centerpiece of the prosecution, meaning to say the accusation against the filing of the SALN, Statement of Assets, Liabilities, and Net Worth by the Chief Justice. It appears to be the showpiece of the prosecution, and therefore we must take time, not only take time out of number crunching, which you were doing last week, and see what the Constitution and what the Supreme Court have said about the filing of the SALN. First, let me begin with Article 2 of the Articles of Impeachment. I will read it verbatim. Respondent committed culpable violation of the Constitution and or betrayed the public trust when he failed to disclose, I repeat, when he failed to disclose to the public his statement of assets, liabilities, and net worth as required under Section 17, Article 11 of the 1987 Constitution. Notice that this heading under the Articles of Impeachment only uses the phrase failed to disclose. If we had disclosed and we are going to apply this article literally and very strictly, then there is no more case, because it turns out now that he disclosed his statement of assets and liabilities as provided by law, as I shall explain later. So in my view, Article 2 is suffering from at least incompetence in phraseology, because if we were to apply it strictly, if there is evidence, and evidence has been shown in this court, that defendant failed to disclose, meaning to say, failed to show his statement or make his statement of assets, liabilities, and net worth unavailable or inaccessible to the public, then he would have committed the impeachable offense. But if he already took steps to do otherwise, then the whole case falls. What I'm saying is that Article 2 should have said when he failed to disclose and he failed to declare, because declare and disclose are two separate things. As we shall see when we look at the Constitution, Article 11, Section 17, a public officer or employee shall, upon assumption of office, and as often thereafter as may be required by law, submit a declaration under oath of his assets, liabilities, and net worth. Notice, therefore, that the first requirement by the Constitution is to file a declaration. You declare what your assets and liabilities are. And then, in the closing sentence, the Constitution says, the declaration shall be disclosed to the public in the manner provided by law. This is the second requirement, the requirement that it should be disclosed. There are therefore two requirements. First, that he declared. Second, that he disclosed. It appears now that the Chief Justice both declared and disclosed, so the case is closed. But in the spirit of liberality, we have taken note of the explanation of the prosecution of its Article 2 on the Articles of Impeachment. Now, let us look at what our Supreme Court has ruled concerning the filing of the SALN under this constitutional provision. In the 203 case of Francisco versus Nagmamalasakit, etc., Supreme Court said, a determination of what constitutes an impeachable offense is a purely political question. We cannot settle it by citation of authorities or by citation of cases. It is a purely political question, said the Supreme Court. The Constitution enumerates 6 grounds for impeachment. 2 of these, namely other high crimes and betrayal of public trust, elude a precise definition. But the issue calls upon the court to decide a non-justiciable political question, which is beyond the scope of its judicial power. Therefore, we are making history with this particular impeachment case. We are deciding a political question. What are the failures or the omissions in the filing of the SALN that would constitute an impeachable offense? Notice that in the United States Constitution, it is impeachable. It is possible to impeach a high public official for crimes, quote, and for misdemeanors. We did not use the phrase and for misdemeanors because misdemeanors in common law systems are mere faults or failures to observe minor ordinances. So our Constitution contemplates a very high crime, we have to see then what is the meaning of a high crime. In the records of the Constitutional Convention, we find at least this sentence: for graft and corruption and betrayal of public trust to be ground for impeachment, their concrete manner of commission must be of the same severity as treason and bribery, offenses that strike at the very heart of the life of the nation. They kept on repeating this clause in the Constitutional Commission: offenses that strike at the very heart of the life of the nation. That is, in pari materia with all those other obviously high crimes that are enumerated in our Constitution. Our question, therefore, is not about how do you distinguish this value from that value, assessed value, acquisition cost, fair market value. We're not number crunchers. This is a quasi-judicial and quasi-political proceeding. This is not a quasi-accounting proceeding. So the question is whether there is any discrepancy or omission in the SALN of the defendant, Chief Justice, that strikes at the very heart of the life of the nation. Now I come to a famous, or, according to your view, an infamous statement that was made by an American president during the attempt to impeach one of the most famous justices of the U.S. Supreme Court, Justice William Douglas, in April 1970. At that time, Gerald Ford, ultimately president of the U.S., was just a representative, and he maintained this infamous statement: an impeachable offense is whatever a majority of the House, or in our case, 1/3 of the House, considers it to be at a given moment in history. So we are actually writing the book for what is an impeachable offense. Conviction results from whatever offense or offenses 2/3 of the other body, meaning to say 2/3 of the Senate, just like the Philippine Senate, considers to sufficiently serious to require removal of the accused from office. So it is for us to decide what is impeachable in terms of the SALN. Now, I have already made a passing mention of the Constitution. Let us go to the laws that are meant to implement the constitutional provision. The first law is called the Anti-Graft and Corrupt Practices Act, RA number 3019. Section 7, Statement of Assets and Liabilities. Every public officer within the month of January every other year shall file statement of assets and liabilities, in the proper case with the office of the President, or in the proper case with the office of the Secretary of the corresponding House or the corresponding chamber. Next law, Code of Conduct and Ethical Standards, RA number 6713. The provision of the first law that we cited, Anti-Graft and Corrupt Practices, was expanded by the Code of Conduct. And it said the two documents, meaning to say the statement of assets, liabilities, and net worth, and the statement of financial disclosure. It says, and I'm quoting, these two documents shall contain information on the following. Letter A, real property, its improvements, acquisition costs, assessed value, and current fair market value. That's all that the law said. It did not indicate how we arrive at these values. It just says that the SALN should contain information on real property, its improvements, acquisition cost, assessed value, and current fair market value. Who determines this? The proper public officials. So there is no need for this impeachment court to argue lengthily on what is acquisition, what is assessed, what is current fair market value. These are determinations made by the proper legal officer. And further, the Code of Conduct provides the SALN shall be filed by, in the case of senators and congressmen, with secretaries of the Senate and the House respectively. In the case of justices, with the clerk of court of the Supreme Court. We have already heard evidence that the Chief Justice filed his declaration, and he filed it with the correct official, the clerk of court, from whom the public may see fit, by the proper procedures, to get a copy. Not only do we have these two laws to guide us, we have to look at its implementing rules and regulations, particularly of the Code of Conduct. The Code of Conduct, implementing rules and regulations, reflects the law itself, meaning to say the Code of Conduct, and providing that the statement of assets, liabilities, and net worth shall contain information on the following. And it repeats, real property, its improvements, acquisition cost, assessed value, and current fair market value. In the implementing rules and regulations, we find the following statement. In the event said authority determines that a statement is not properly filed, they shall inform the reporting individual and direct him to take the necessary corrective action. The individual to whom an opinion is rendered, and any other individual involved in a similar factual situation, and who, after issuance of the opinion, acts in good faith, underline, acts in good faith, in accordance with it, shall not be subject to any sanction provided in the code. Underline, shall not be subject to any sanction in the code. This is the basis for the theory by some that since any failure or omission in the SALN has now been decriminalized, it should no longer be considered an impeachable offense because of this provision in the implementing rules and regulations of the Code of Conduct. And there are certain provisions that are provided for failure to do so. Now, we have looked at the two laws. We have first looked at the constitutional provision. We have looked at the provisions of the two major laws, the Anti-Graft and Corrupt Practices Act and the Code of Conduct and Ethical Standards. Now let us look at the even lower level of legislation, the Civil Service Rules. You all know by now that the recent guidelines issued by the Civil Service Commission are supposed to govern declarations made for 2011 and thereafter. And there are definitions of terms in this guideline. But among the most salient provisions of the guideline is, for computation purposes of real properties, acquisition cost shall be used. That's what the law says. You use acquisition cost. In the past, people did not know what to put in their SALNs, and the law did not say anything. Then eventually the law said you can put either acquisition cost, assessed value, or fair market value. Civil Service Commission in practice ruled, although the conjunctive is used for these three values, the conjunctive of and, actually it should be interpreted as or, so you could just choose any of the three. But now we have in this new guideline by the Civil Service Commission that when we compute our real properties, we should use acquisition cost. There's no more question about this. If the public officer fails to comply with the law, he can be charged under the penal code with a crime of falsification for untruthful statements or for perjury. So we have taken a look now by this time at the Constitution, the applicable laws that are meant to enforce the Constitution. But let me go more deeply into the matter of the failure to disclose or the failure to declare or the omission of any declaration. The Civil Service Commission issued the recent guidelines that will govern 2012 and onwards. And it declares that for computation purposes of real properties, acquisition costs shall be used. So you and I, as members of Congress, of the House of Representatives, and of the Senate, beginning from 2012, should now use acquisition costs for our SALN. But before this guideline by the Civil Service Commission, our bureaucracy was governed by the older guideline issued by the Civil Service Commission in 2006. 2006 resolution of the Civil Service Commission does not provide any guideline. The SALN filed by Chief Justice in 2011, but covering the period of 2010, as well as all his previous SALNs, was filed according to the old resolution of the Civil Service Commission. I have already said, and I repeat, according to Civil Service Commission, at that time, under the old guidelines, which was very deficient, or let us just say non-specific, it is not necessary to fill up all three values. You could just choose among fair market value, assessed value, and acquisition cost. Now let's come to the question, how should the current fair market value be computed? We have already been told that there are provisions in the local government code because the municipalities formulate a schedule of fair market values, and this is what is applied by the city assessors. In our present case, the defendant based the valuation of the assets in his SALN from the fair market valuation enacted by local ordinances. However, the prosecution contends that the defendant should have used the value by which a buyer is willing to buy the property and the seller is willing to sell. This is the argument that uses the antique, the age-old, centuries-old possibly, definition by an English writer called Sedgwick in his book Sedgwick on Damages, and cited in a 1919 case by the Philippine Supreme Court, defining market value as that reasonable sum which property would bring on a fair sale by a person willing but not obliged to sell to a person willing but not obliged to buy. I don't see what would be the utility of discussing what should be fair market value. We should be discussing the question of whether the defendant committed an impeachable offense when he allegedly erroneously misdeclared certain entries or completely omitted certain entries in his SALN. Let us see and I come now to the gist of what I really wanted to say. Let us come now to what the Supreme Court has to say. When you fail to properly and completely file your SALN, what are you committing? What crime are you guilty of? In the most recent case, 2011, Presidential Anti-Graft Commission v. Plato, spelled P-L-E-Y-T-O, PAGC versus Plato, promulgated in 2011, the Supreme Court answered, the failure is not dishonesty but only simple negligence. That prosecution panel should be the topic of your next oral manifestation, and particularly your written manifestation or memorandum at the end of this trial. Here is the Supreme Court speaking, and only as of 2011, Plato's SALNs are prepared by a family bookkeeper/accountant. Also, his wife has been running their financial affairs, including property acquisitions, which form part and parcel of her lending business. Thus, he was not directly involved, and he failed to keep track of the real property acquisitions. Here is the important sentence. Consequently, petitioner's SALN was not filed in proper form, containing several inaccurate information. The court had no doubt that the SALN was inaccurate, but it went on to make distinctions among these three terms: gross misconduct, dishonesty, and negligence. It cited the two standard laws, remember, that we began with, the Anti-Graft and Corrupt Practices Act, and then the Code of Conduct and Ethical Standards. This is what the Supreme Court said. For gross misconduct to exist, there must be reliable evidence showing that the acts complained of were corrupt, or inspired by an intention to violate the law, or were in persistent disregard of well-known legal rules. That's what you have to prove, prosecution. The Supreme Court went on, and as for dishonesty, it is committed by intentionally making a false statement in any material fact, or practicing or attempting to practice any deception or fraud in securing his examination, registration, appointment, or promotion. And then finally, negligence. Negligence, said the Supreme Court, is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. In the case of public officials, there is negligence when there is a breach of duty or failure to perform the obligation, and there is gross negligence when a breach of duty is flagrant and palpable. The Supreme Court goes on. Gross misconduct and dishonesty are serious charges which warrant the removal or dismissal from service of the erring public officer or employee, together with the accessory penalties. Hence, a finding that the public official is administratively liable for such charges must be supported by substantial evidence. Prosecution, you have to show at least substantial evidence because this sentence was made in a decision that involved an administrative case, but we are trying an impeachment case. The Supreme Court held that Plato's failure in properly and completely filling out his SALN was not intentional. Supreme Court said, clear from the foregoing legal definitions of gross misconduct and dishonesty is that intention is an important element in both. Missing the essential element of intent to commit a wrong, this court cannot declare petitioner guilty of gross misconduct and dishonesty. An act done in good faith, which constitutes only an error of judgment and for no ulterior motives and or purposes, does not qualify as gross misconduct and is merely simple negligence. And so in the Plato case, the Supreme Court said, thus, at most, petitioner is only guilty of negligence. You have your work cut out for you. Prosecution panel, show that an omission or a misdeclaration was deliberately intended by the defendant. You must show essential element of intent to commit the wrong. Now, in another case, the court found that the defendant was guilty and should be removed from service. The Office of the Ombudsman v. Racho, also a 2011 case. So we have two cases to choose from because the latest case always controls the jurisprudence. In this other case, Ombudsman v. Racho, the court found Racho guilty of dishonesty for non-disclosure of his bank deposits in SALN. Here is a note of caution to the defense. Defense panel, has your client, the defendant, disclosed in his SALN all his bank deposits, peso and dollar deposits? Because if he did not, but he admits that he made those deposits, then under the ruling in Ombudsman, under the ratio decidendi, then your client is guilty. In this particular case, the Supreme Court defined dishonesty. It said, dishonesty begins when an individual intentionally makes a false statement in any material fact or practicing or attempting to practice any deception or fraud. And then finally, just for emphasis, one more case that challenges the position of the defendant. Carabeo v. Court of Appeals in 2009. He was officer in charge of the treasurer of Parañaque City. He accumulated several properties and was able to travel abroad 15 times. He did not disclose this in his SALN. He alleged as a defense that he can simply correct the entries made in his SALN. But the Supreme Court said that while the law indeed allows for corrective measures, the defendant was charged not only with violation of the Anti-Graft Act, but also violation of the Penal Code. He failed to show any requirement that prior notice of the non-completion of the SALN and its correction precede the filing of charges for violation of its provisions. I will now stop myself. I will challenge these two panels. Number one, prosecution, show that there is intent to commit dishonesty on the part of the defendant and you've won your case. On the part of the defense, show that your client has, in good faith, declared in his SALN all his deposits, both peso and dollar deposits, and if he did not, why not? Please take these cases, decided cases that I have cited accordingly. Thank you.
Thank you.
Mr. President,
Dr. Floor Leader.
Mr. President, Senator Joker Arroyo wishes to be recognized.
The gentleman from Makati and Bicol.